Imagine if the most popular rifle in America, the AR-15 and magazines, were declared outside of the protections of the Second Amendment. That's not just a hypothetical, that question is now up for consideration in the Supreme Court. And the question before the court is a very simple one. Does the Second Amendment guarantee the right to possess AR-15s and magazines? So let's talk about the news in this case and what's currently going on in these critical challenges. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also double check to make sure YouTube is not unsubscribed you. And then also, I want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're actually backed by a real law firm, the Attorneys for Freedom, and they're always expanding upon their benefits. They're always trying to give the members as much as possible. And one of the new things that they added is that they are guaranteeing 4 attorneys to your self-defense case. So if you're interested, check them out using my link down below. And if you use my code ARMEDSCHOLAR, you can get $25 off of your sign-up fee. As I mentioned in the intro, in this video, we're going to be talking about a critical rifle and magazine ban challenge that's currently in front of the Supreme Court and is once again heading to Supreme Court conference this week. The primary case that I want to talk about is Vermontes versus Cook County, and in that case, you have some petitioners, some individual citizens, along with some 2A organizations which are suing that county. They're challenging Cook County's ordinance, which makes it a crime to sell, transfer, or even possess so-called assault weapons. And that term in the county and in that ordinance makes it so that essentially 100 and more rifles by name, including AR-15s and AK-47 platforms, are banned as so-called assault weapons. And then they also have a characteristic and feature ban where if a semi-automatic rifle has something like a pistol grip, a folding stock, a muzzle brake, or anything like that, it is also classified as a so-called assault weapon. The plaintiffs argue that this ban doesn't just regulate firearms, it outlaws some of the most common and popular rifles in America, which are in fact protected by the Second Amendment. And they also say that this cuts straight against what the Supreme Court has already decided in some of their cases and some of their precedent, like Heller and Bruin. This case also tries to leverage the recent statements made by Justice Kavanaugh after the Supreme Court denied the Snope rifle ban case last term. And in that denial, you had Justice Kavanaugh make a statement, and he stated that the time would come very soon that the Supreme Court would need to take up a rifle ban and that would happen in a term or two. The plaintiffs now push this case as the perfect case and the perfect vehicle to finally fulfill that promise. And the Supreme Court has once again relisted review of this case and also the Duncan magazine ban challenge, which comes out of the state of California. And this could mean a few things for the future of these cases going forward. But this week, the Supreme Court has once again, they've redistributed them, and they're going to be going to conference this Friday. Now, here's how this rifle ban got in front of the Supreme Court. Essentially, in 2021, the rifle ban lawsuit was filed in a federal district court in Chicago, and the petitioners challenged the county's ban under the Second Amendment. So in 2024, while the case was pending, Illinois passed a statewide assault weapon ban through PICA, overlapping with some of the language in Cook County's restrictions. Around the same time, the Seventh Circuit decided a different case called Beavis versus Naperville, upholding Illinois' law and claiming that AR-15s were too militaristic to be protected arms. They ruled that firearms that are useful in military service could be outright banned, and the district court bound by the Seventh Circuit in this case ruled in favor of Cook County and upheld this rifle ban in this ordinance. The district court issued a summary judgment in favor of Cook County, and essentially in 2025, right after Snope, that petition was denied, like I mentioned, where you had Justice Kavanaugh make a statement saying that they would take a rifle ban case in a term or two. Well, that also impacted what was going on in the Seventh Circuit in review of this Cook County case. Because after that denial, I believe that the Seventh Circuit felt free to simply just reject this case, to not review it. And essentially what it really did is just uphold what had already happened in the lower court, and it leaned heavily on Beavis, treating AR-15s as essentially the civilian version of M16s and therefore outside of the Second Amendment's protections. And because of that, now the plaintiffs and the petitioners in this case are asking for the United States Supreme Court to step in and resolve this conflict. They asked for the Supreme Court to declare once and for all whether Americans have the constitutional right to own AR-15s and similar semi-automatic rifles that states are just outright banning. The petition argues that the circuit courts are split and deeply confused on how to apply Heller and Bruin, and some courts say that AR-15s are arms, but they can be banned or restricted anyways. And then others, circuit courts in other areas claim that they are not protected arms at all. The petitioners in this case say that the Supreme Court needs to clarify that all firearms, including semi-automatic rifles, are arms under the Constitution and they are afforded two-way protections. They point out that Cook County and the 7th Circuit rely on the idea that AR-15s are military firearms or they're too militaristic. However, the whole useful and military service analysis that was used by the 7th Circuit and other circuit courts as well, it was essentially never part of Heller or Bruin or that analysis, and therefore it should be rejected and struck down by the Supreme Court. Now, Cook County responded to this by arguing that the court should once again just simply punt this issue, deny review of this rifle ban case, and just simply not get involved. In summary, they say this case is procedurally defective, legally settled, and not the right vehicle for Supreme Court review or for them to even revisit or relook at this whole assault weapon ban question. So at its core, this case asks for the Supreme Court to finally do something that we've been asking them to do for a really long time, for many years, which is to strike down a rifle ban, an ordinance or some sort of comprehensive ban on so-called assault weapons. Now, both of these cases have been relisted, multiple times, I believe twice now. These cases have gone to conference. In the order list, there was no denial, but they were simply relisted for a new conference. And now this week, on Friday, January 9th, they're going to head to their third conference to the Supreme Court. Now, you may be wondering, why is the Supreme Court relisting a case so important for the outcome of what could happen? Well, that is because all of the Supreme Court analytics and tracking on prior cases show that a case has a higher odds of being granted review by the Supreme Court if it's relisted, but only one time. In fact, according to the data for the court's 2016 to 2020 terms, between 31% and 43% of petitions that were relisted at least once were eventually granted review. So the fundamental truth is that a case relisted just once has a far better chance to be granted review by the Supreme Court, but also all the data shows that multiple relist, like what is currently happening in this case and what we've seen happen in other cases like Snope, that rifle ban issue, typically that can be a bad sign. However, there are some outliers like we've seen with the Cargill bump stock case and a lot of these other, two-way cases. Those were relisted, I believe, like 12, 14 times and yet still granted review. So it's not a bright line rule. There are some outliers, but it's definitely something you want to keep an eye on. Multiple relists often can indicate that the case is going to be denied review and that maybe one or more of the justices is interested in writing a dissent in that denial, and that's why it's being relisted multiple times. So there is still a chance that these cases being relisted is not a bad thing yet. It's not a bad thing right now. However, if we start to see these cases get relisted even more times as they start to jump up higher and higher numbers, that could be a bad indication that potentially they're going to be denied and you're simply going to have something like a dissent written in those cases. To this point, the Supreme Court has avoided the whole rifle and magazine ban question like the plague. However, we will know very soon whether Kavanaugh is going to stay true to that promise or whether that was an empty promise when he said that they would take up this issue in a term or two. And we'll find out if they will continue to avoid this issue and allow the lower courts to essentially run amok. And so all eyes will once again be on the Supreme Court this Friday for the next conference in these cases on January 9th. However, I will also state some of the good things with these two cases, how they've survived two relists, two conferences, when you had some other cases, some other 2A issues that went to those same conferences dealing with magazine bans and NFA SBR cases. Those were outright denied the following week. However, these cases survived, so that's also maybe a silver lining that there is at least some interest in these cases in the Supreme Court. So again, we're going to keep our eyes on the Supreme Court conference and the following week for the order list to see what the Supreme Court decides to do in these two critical cases. So that's what's currently happening in these critical rifle and magazine ban challenges. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm. Also, you can check out one of the two videos here on the screen that the YouTube algorithm thinks that you will find helpful. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.